Should I cough like as a segue in from that? I think that'd be wonderful. But I'm drinking my coffee here, and I actually wanted to sip it really loud, but you won't let me do that anymore, so I won't do that.
No, it's you can sip it. Well, you can't sip it loudly. You can't slurp it
I
because
can.
that's essentially a loud sip.
Look,
Sip is a slurp.
it's. I mean,
And
that's a
I don't
that's a
want the
first.
first thing our listeners hear is
Okay, but we have a First Amendment right in this country to slurp. It says it right there in the wording. I mean, you have to look at it really deeply,
just
but it's
because
there.
in the Constitution,
Okay.
Gary, doesn't mean that you should do it. It could be rude.
Okay, here's the deal.
Is this how you conduct yourself in a democracy?
Correct me if I'm wrong, Omar, but I believe you're allowed to be a racist in the Constitution.
Well, yes, you're also allowed to poop your pants in public. Doesn't mean you should.
Yeah. So it's just manners, Gary. That's all we're trying to instill in you.
All right, here's the deal. It's Sunday, guys, and it's not just any Sunday. This is legal Sunday, and because it's legal Sunday, I have to put in this disclaimer. The words, actions, and thoughts of the people here do not necessarily represent the words, actions, and thoughts of anybody else out there except for the state government, which is really fucked up. And we'll talk about that and a couple other things on the rotation. Let's jump in. May I just say that new music really does make my organs quiver? It's got that bass beat that just makes everything work well. Well, anyways,
the intro video is it's now like our original theme song and everything. And
it is wonderful. It is wonderful, and we are ready to go. My name is Gary Sion, the political director here at Suncoast Normal.
Oh, sorry.
And our master of public health. And our engineer, who down below me is working on his sound effects, is our deputy director, Carlos Angel Armida, and master of business administration.
Thank you, everybody. Thank you.
You're wearing that abominable shirt, aren't you? Yes on 3. But is 60% of you yes on 3? That's the real question.
Just because the campaign's over doesn't mean I didn't get a free shirt.
Plus, it's green. And to the right of me and your left, I think, is our executive director with his Christmas regalia behind him, which is actually virtual. Our Christopher Cano. Chris, how are we doing over there above the Beltway?
Oh man, with everything happening in DC, it's still a shit show as we would characterize it. For every step forward, there's like 2 steps back. One of the things that happened in the past week was President Biden issued out a whole bunch of pardons and commuted us several sentences. But one of the ones that he commuted was that judge that was taking bribes from the private prisons to lock teenagers up for marijuana charges for ridiculous amounts of time. And so it's no wonder liberals and Democrats lose elections so goddamn much.
But that's what they call equity. And our guest today comes from the area that we constantly hear in Tallahassee as being the wild, wild west. Coming to us from California, their counsel extraordinaire, our counsel normal extraordinaire, Omar Figueroa. Omar, how you doing out there?
I'm doing most outstanding, and here in Sonoma County, California, it's a gorgeous day, and I hope it's gorgeous out there in Florida too.
Have grapes still outdistanced the amount of cannabis grown in the Napa Valley?
And also in Sonoma County, yes, by far. But when you look at like the economic output of an acre of cannabis versus an acre of wine grapes, cannabis is far more economically productive. And so now that they're doing these economic impact studies, it's clear that cannabis is, once it's federally legal, it's going to be leaving wine behind.
Well, here's the question I have for you in California straight out. You have this crazy idea that localities can surpass state law all the time. So therefore, no matter where you go, it's not really the fact that you're in California. It has to be what county you're in California. And some people who actually are doing delivery services.
What city? So we have 58 counties, 482 cities, and every municipality gets to make up their local rules for cannabis. And that's a crazy contrast when you look at the alcohol industry, where there are no local bans on liquor stores or on gas station sales of beer. But with cannabis, it's prohibition light.
So you're saying that alcohol has free reign and cannabis is being reined in. How unusual! And yet that's the wild wild west. That is basically, and of course Jason had to kick in. It's good to see they let you out of Mar-a-Lago for a while, Jason.
Well, I think the conception of California as a Wild West, it's outdated because it used to be the Wild West during the era of collectives and cooperatives, and that ended in 2009. And so now we have the most regulated industry in California, sort of like nuclear, and that's cannabis. There are so many layers of bureaucracy, local government, multiple state agencies. It's absolutely overregulated. So it's no longer a Wild West on the regulated side. At the same time, two-thirds of the cannabis industry in California is unregulated. And it's because the cops don't bother with misdemeanors. And most cannabis crimes were reduced to a misdemeanor after the passage of our ill-advised initiative, Prop 64. And so Prop 64 um, was put forth by a billionaire, and it was the Control Tax and Regulate Cannabis Act. And the whole idea was that the sky would fall once cannabis was legalized, so they had to do it in a very, very restrictive fashion. And rather than outright legalized, which we don't have anywhere in the United States yet, it's semi legalized.
You
I
know,
have. Go ahead,
I
Chris.
just wanted to add, Gary, the issue that I've seen with California, that I've gotten feedback from, normal of California members, from members of the We for Warriors project, is really what we've been, harping on in Florida, as they want to transition from medical to adult use, is let's not tax this back into the illicit market. The main reason people want to purchase from a legal market is for that peace of mind as a consumer, to know that your stuff is tested, to know that it didn't get laced with anything. I mean, that was one of the key talking points that we saw in the Amendment 3 campaign in Florida. Now, the Amendment 3 campaign, whether you have issue with who was funding it or how it was being carried out, that was still a valid point of the campaign, is that consumers want peace of mind to know that they're purchasing a quality product. But just like we saw recently with Jay-Z's cannabis company, you also can't sell $70 joints and expect people to actually want to purchase that when you can get an ounce here in the DC DMV area for $75. I mean, the markets across the country are very different depending on regulations, depending on whether or not you can grow your own personal cultivation. One of my favorite things in the old school High Times magazines was to see what things would cost around the country, and they would say an ounce of booth in Idaho, $250, versus some really good stuff in California for $100. So
Now, a friend of mine who's a grower in California, hands out to you, Benny, has always said that the two things that are holding back the cannabis industry are the occasional fire and the regulations. Because of the fact that there are people who have actually gone broke waiting for their license to become legal, so they have to go back to selling on the legacy market because they have no choice, otherwise they go bankrupt. Is that still the situation?
Yes, and it's really because of federal taxation and 280E. This allows, the people from writing off their ordinary and usual business expenses, such as rent, employees expenses, advertising, like just legal compliance. Like every aspect of it is not tax deductible. So it's super heavy regulations that you can't write off. Is really like the beginning of it. And then the occasional fire, as they said. And we also have earthquakes and other calamities in California. So being a farmer, people think it's like an easy job. All you got to do is, plant seeds in the ground and then kick back until harvest. And that's not really the way being a farmer is in, modern society. Like it's not like this idyllic, just like, chew on a corn stalk until harvest. But people are dealing with very complicated regulations, and on top of that, all of the vagaries of the weather and nature, and sometimes it's raining, sometimes there's hail that will like kill a crop. And so I think being a cannabis farmer is one of the toughest jobs out there, even though the perception is that you don't really have to be, very good at your job to do it. But the reality is it's so competitive. There's so many people trying to do it. You better be at the top of your game if you want to be able to sell your cannabis either in the legacy market or on the regulated market, because our consumers in California are very sophisticated. They're also looking for the best bargains, and they don't have a lot of brand loyalty. They don't care what brand is on it. They're just looking for good product at a great price.
Well, here in Florida, we don't have a good product at a great price. Although the price is going down because we've had various factors that have been driving that price. That echo in there somewhere for me, but 280E. That brings me to the topic of this whole concept of possible rescheduling. Have you been following what's been going on over the last couple of weeks in regards to that?
Oh yes, and I think the IRS has even said that as soon as the 280E, as soon as rescheduling final rule is published, that you can start writing off your ordinary and usual business expenses. But that's great news. What sucks is that they put off. I hear an echo, but what sucks is that there's that they put off the rescheduling hearing, and it looks like now it got continued from this year to next year. It may happen quickly in January. It sounds like the administrative law judge Mulrooney is trying to proceed as fast as possible, but I'm not sure it's going to get done in the first quarter of 2025.
I'm concerned about, number one, the people who were asked to come and speak versus the ones who requested to come and speak. As you know, Paul Armentano was told, no, you don't have any standing, so therefore you can't come. But they sent out this guy, Nick Garrelay, who the judge shot down as soon as he opened his mouth, saying, you have no say here because you don't know anything.
Right.
So it's really confusing as whether they're moving forward or they're looking for a place to land it, off the runway as opposed to on the runway. Using the plane metaphor we get constantly from our legislators over here. Let's land the plane. But it's not landing, I don't think.
Right. Well, I think that Mulrooney doesn't know where he's going to land the plane right now. He's just waiting to see what the flight is like. And then at that point, he'll decide where he's going to land it. So right now, I think we're in an area of uncertainty when it comes to rescheduling. I think rescheduling, as much as it would bring federal tax relief, it's really just like semi-legalization. It's not the complete answer. It's a half answer. It will halfway get us there. But really, cannabis ought to be descheduled. When you look at all of the factors for scheduling, cannabis doesn't fit into Schedule 3 either. There's 100% THC dronabinol, which is a Schedule 4 controlled substance. So that puts the lie to descheduling right there. How can 100% THC in chemical form be Schedule 4, and we're talking about scheduling the safer whole plant cannabis as Schedule 3? It just shows how even if we do deschedule, we're still in crazy town.
I concur, and I always say, just having straight THC is like having an engine with no steering wheel on your car, and that is essentially why it's actually safer, because the things like terpenes actually guide the THC and actually make it work. Whereas straight THC, like I say, is an engine. You can't drive an engine. You have to have some kind of apparatus to actually steer where you want to go. And that is what I see as possibly happening. Now, if we do get rescheduling as opposed to descheduling, we can make some hay out of it. Like, for instance, here in the state of Florida, they made it illegal for any rehab facility to have access to cannabis. Anybody in a rehab facility to have access to cannabis, which makes it kind of tough if you're trying to use cannabis for opioid remediation. And that's basically what
Absolutely.
we've been going for.
Yeah, you could be prescribed pure dronabinol, but we know that's not going to be effective because it's just pure engine with no steering wheel.
And so we already have a bill set aside right now that if rescheduling goes into play, we are going to demand that a bill get put into place that allows cannabis remediation in rehab facilities, because it'll show at that point in time that there is a medical benefit to it. So we can go ahead and do it statewide, even though you have a lot of these rehab facilities that use federal funds, which is one of the reasons they shut it down in the first place.
That's a really good
Gary.
point that I hadn't considered yet, Gary. And I think that is one of the immediate benefits of rescheduling, that people in rehab facilities will be allowed to use whole plant cannabis instead of having to go for the 100% THC Marinol Dronabinol that's available.
You know, Omar, I gotta say, you know, I'm not optimistic on the Schedule 3 simply because normal when we first challenged back in the 70s and got a ruling from the DA in the 80s, their administrative law judge at the time said that, you know, cannabis has medicinal value, and the DEA continued with Schedule 1 status, and the federal government continued to allow it, you know, essentially for most of my lifetime. And then, you know,
That's a good point. Administrative law judge Francis Young, in an opinion for the ages, said cannabis is one of the most therapeutically active, one of the safest known therapeutically active substances known to man. And I think, that they ignored their own administrative law judge just shows contempt for the rule of law. That's a really good point. Like, even if Judge Mulrooney says that cannabis ought to be rescheduled, he can just be ignored,
Yeah. And then, when we talk about laws, let's talk about the people who make the laws. We're looking at the U.S. Congress. They can't even get cannabis banking done. Chuck Schumer said that he can't get the votes from the other side of the aisle on the Safer Banking Act to bypass the filibuster rules in the Senate. And, Mike Johnson is not going to call for a hearing in the House. So we're looking at cannabis banking, for existing legal businesses done. I just feel like we're going to be in this status quo holding pattern for another 4 to possibly 8 years, depending on how elections go. I'm not saying the Democrats are the party of legalization, because they can't even seem to get their own house in order when it comes to elections. I mean, for the last 3 primaries, the party has fixed the primary to make sure Bernie Sanders couldn't become the president. So it's definitely a shit show on either side of the aisle. And the incoming Senate leader Thune from Dakotas is skeptical of marijuana legalization. You see a lot of Trump appointees. Folks are really excited to see Matt Gaetz at first in the cannabis sector in the RFK, but now you're seeing things shape up with Pam Bondi leading the Justice Department, and it's just not looking promising over the next few.
Well, Gaetz, by the way, he has this new job at OAN, which is kind of nice. Kind of keeps him at bay, but he is planning on running for governor here in the state of Florida for the next cycle after DeSantis terms out, which is absolutely horrendous. But he was the person who started the cannabis industry here in the state of Florida by helping to pass that first CBD bill. And so we're hoping that actually does work out. Speaking of governors, your governor did some very interesting things this last couple of months. First off was Assembly Bill 1775, which I remember because it's one bill short of actually signing some declaration of something. And what basically did the Assembly Bill 1775 say?
It's this cannabis cafe bill, and starting on January 1st, it's going to allow dispensaries to not only offer on-site consumption, which some can do now with local approval, but also to sell freshly prepared food and beverages. So basically, you're going to have a dispensary with a restaurant inside it and a live coffee shop. And on top of that, they're allowed to sell tickets to live events. So you could have like live concerts, all sorts of performances, because California has a very strong art scene. And so it wouldn't just be like, musical performances, but I also can imagine like poetry, art, all sorts of interesting multimedia art events that are participatory, where people can use cannabis, eat food, and do fun stuff. And that's known kind of like the Dutch model, like the Dutch coffee shops as a harm reduction measure. They, of course, it makes sense to allow people to consume food and drinks when they're ingesting cannabis. It's just basic harm reduction.
Well, we have what's called the Florida model, where you have a pop up and you say "fuck the law," and
Uh-huh.
that's pretty much what we do at Dab Day at Art Basel in Miami and across the state. So it's interesting to see how things are going to shake out, because last year the Florida legislature actually tried to pass a law saying that we couldn't hold events with hemp vendors without getting a permit. Luckily, Carlos and several other hemp businesses went up to Tallahassee, advocated to kill that bill. But scuttlebutt is those bills are coming back around, and even then, the Florida Department of Agriculture is doing their best to crack down on the total amount of THC available in hemp products. In Florida and other prohibition states, even the ones with medical programs, the hemp industry has really thrived because people like the idea of not having to spend $300 on a doctor's recommendation to go get those products. And so it's
$300. Mine costs 35.
In Florida, it has been a moneymaker in a lot of ways. You can spend anywhere between $100 to $300, depending on the doctor, depending on the recommendation. It is just sad. And then that only lasts for 270 days. So at least twice a year, you're dishing out money that your insurance doesn't cover to get a doctor's recommendation in Florida.
So
Yeah,
medical cannabis for the wealthy only.
Well, it's interesting here in Florida. We have doctors making money as they should, because those clinics have high overhead. They have to have clinical staff, that kind of thing. And they have to create these things in order to put out those things. It's not a matter of having a guy putting up a shack on the beach in Venice and saying, marijuana doc, license, medical card, $40. Isn't that what it used to be?
Yeah, now that there's so much competition, the price is going down. There's price pressure downward.
That's amazing. But here in the state of Florida, I mean, the government, they don't want to tax it, but they tax it by, number one, an application for a dispensary costs $160,000, and you have to wait 2 years for the results. And they don't care if the fact that the guy who wrote the application dies. Nobody in your family can actually get it. But we're working on that, along with several other things. We have 22 new licenses that were given letters of intent, and they have the next 120 days, 160 days to be able to meet all the benchmarks, including putting up a $5 million performance bond to be able to actually turn that letter of intent into an actual license. And yet most of these people who got it, a lot of them didn't even know they were going to get it. They had no idea that they were actually good enough to get it, because all they're trying to do is trying to get the license and then sell the paper license before any infrastructure is built. And yet we're saying, no, you have to have some infrastructure for the letter of intent to become an actual license. So it's going to be an interesting shit show to see if somebody borrows the money to be able to create the cultivation so they can go ahead and sell the license without actually creating any real product for the public. But that's the wild southeast of Florida.
So it seems to me with that kind of dynamic, there's probably going to be lots of bodegas like there's in New York, bodegas left and right, and a thriving underground economy.
Well, we have the hemp industry here, which Carlos is deeply into, which I wanted to bring up too, because of the fact that his industry relies very heavily on the sale of TCHA products, as well as Delta 8 and Delta 9 derived from hemp products. And they've changed that a bit in California, haven't they?
On me, Gary. TCHA.
Did I say wrong? Yeah, TCHA. What's going on in California in regards to TCHA? The governor has something to say about that too, correct?
Well, the governor, issued or proclaimed emergency regulations, and so now, Delta 8, all the other isomers plus THCA, or they're all illegal in California and can no longer be sold. And so there's a lot of hemp shops that had to close overnight and basically ship their inventory, to other states or sell out of state, because you can still have a shop in California that sells across state lines to other states, but you're not allowed to sell within California. Enforcement has been totally inconsistent. There really the ones that have ABC, which are the alcohol licenses, they're the ones who are immediately pulling the hemp products from their shelves because they don't want to lose their ability to sell alcohol. But other stores that don't really have that type of licensing have not been affected by these emergency hemp regulations. So I think, ill-advised attempt to protect the cannabis industry from unfair competition, but just the way it was done and the way everything has unfolded, it's almost like if somebody had tried to design a system designed to fail, they could not have done a better job.
Wow. I mean, first off, is the Inspector General of the Post Office opening up boxes to see if there's licensed product in there? That's my first concern. I think there's a lot of folks getting high in the back of the post office after they opened up everybody's boxes to see if there's any cannabis in there. But it's interesting that they're not actually challenging interstate commerce.
What's funny is the post office, I would say that there's one of the more careful, shipping agencies, just because they're so regulated, and there's a federal agency, the postal inspectors, criminal division, that are always looking for stuff. So, I don't think they're like opening stuff and getting high in the back of the post office. But when you look at private shipping companies, that's absolutely happening.
Really? Yo, I honestly, like, I love using the post office for my company. Like, they honestly seem to be the most friendly. I've seen like the post office set up booths at like hemp shows, and wow, just to be like, hey guys, listen, we're hemp friendly. As long as you follow these rules, we won't really fuck with you. And I've never had any issues. Any product that I've had shipped in, they might have opened it up or something like that just to check, but they close it back up and send it to me. Maybe it's like a small delay.
We've been dealing with this in Florida since the very beginning, and I want to apologize to the entire country for what you're about to go through if Pam Bondi comes in as AG.
What's her attitude on cannabis and hemp?
It depends what the governor wants.
And she typically works for a governor or person that does not like it.
So she's going to be Trump's right arm woman, I suppose, as well as looking like a Fox News host. She fits right into his idea of what his cabinet should be like.
Right, out of Central Casting.
Exactly right.
From the 1950s.
Well, I got to say this much. I'm not going to ring the alarm bells around doom and gloom around everything on cannabis over the next 4 years, simply because there are so many other things that are fucked up in this world that I almost feel like I don't think the Trump administration is going to have time to even address issues in cannabis, whether good or bad, right? I just don't necessarily see it. I don't see Pam Bondi as bad of a pick as Jeff Sessions was. I'm hopeful in the sense that she'll kind of leave the status quo the way it is. I don't think there'll be a new Cole memo, if you will. But Congress has essentially taken that up in its budget riders each and every year. And that's really where the main concern and focus needs to be for folks who want to organize around cannabis right now, is to focus on the Congress. Because, again, you have a Senate leader coming in who is not cannabis friendly. And then, of course, the Speaker of the House obviously is going to be focused on a lot of other things. Cannabis bills haven't been brought up for a vote. But the one point of promise I saw was in the 2020 lame duck session, they did pass the MORE Act in the House. And so I think that there's still opportunities to get some type of movement on cannabis. For example, like the Doobie Act made it out of committee. I think at least at a minimum, worker protections for medical cannabis patients and members of the armed forces who are not on active duty, possibly even the VA doctors' recommendations. I think those are things that are small victories that could happen over the next 4 years, depending on how well we organize and mobilize, strategize, the members of Congress. But here in Florida, for the past several years, Omar, we've worked to get a worker protection bill passed. We've even watered it down to just public employees, and we can't seem to get anywhere. You know, what were y'all able to do in California? Because we even have a bill that I modeled after what you all did in California to protect patients from medical discrimination, like getting kicked off the organ transplant list. So these are some of the bills that we're going to continue to advocate for this session here in Florida. But I wanted to hear how you all were successful and just maybe some points of view of how you do things out there that we could bring here.
Yes, for example, our employment rights bill, it took like dozens of legislative sessions to make that happen. So really the lesson to be learned from that is never give up. You know, California normal, like just kept going and going. And, you know, it always got pretty close and got vetoed or almost, you know, got defeated in committee. And they just never gave up. Keep introducing it because one day the politicians are going to catch up to the will of the people. And so I think there is no magic way to, you know, I think that the way they framed the issue was, why should you be punished at work for your conduct off work? And so framing it like that in terms of personal liberty to do what you want when you're not at work, to engage in conduct that is legal under state law, I think those are ways to frame the issue. You know, I think that appeals to the both sides.
Now, the way we framed it here in Florida, because like we have a medical law here and only,
Yeah.
even though it is one of the largest markets in the country, even though it's only medical, is that we have an Americans with Disabilities Act, which states that if you have a disabling condition, you have to be allowed you have to be allowed certain things in regards to work in order to have access to your medicine and things of that sort. And so therefore we go with that. We were only allowed to get a bill so far that covers government employees because they're afraid of just cause situation. But there is good news on the horizon. And with that, I wanted to introduce a couple of special guests we have going on, which we didn't tell you about, Omar. Do we have those guys in the background now? There you go. What we have here is Mike Minardi with his new charcuterie over here.
Hey, Mike.
And one of the top cannabis lawyers here in Florida, probably the top one. Nobody else wants to admit it. And his co-counsel, Larry Krutchnik, who won a seminal case here in Florida. Mike, let's talk about it.
Yeah, before you're right, my friend, you know, we've been working on this for years, and so we kind of hopefully made a little dent in the chink in their armor with this past lawsuit here against Hillsborough County for a paramedic who was licensed by the Department of Health as a paramedic, and we are going to require the Hillsborough County.
I'm sorry to cut you off, Mike, but we're having some difficulties hearing you. The mic.
I hear some static in there.
Yeah.
If you want to start.
I don't know if you have a way to fix it real quick, or maybe Larry can speak on this.
Yeah, sure. I can jump in. Hi guys. Thanks for having me. So basically, this is as Gary said, a very big case for employee rights. Essentially, our client, Mr. Giambroni, was terminated from his position as a fire medic because he simply tested positive for having tested positive for THC or medical marijuana. He then, in accordance with the policy of the county, Hillsborough County, he provided his valid medical marijuana card. He followed their protocol, and they said, "Well, we don't care. It doesn't matter that you have a valid license. We don't care. We're not allowing our people to test positive for medical marijuana, even though you followed our policy." And so it was really quite astounding to Mike and I, and we obviously pursued the case because of what he did. And frankly, one thing I forgot to mention is that the test was supposed to be treated as a negative when he presented the medical marijuana license, and they were supposed to just let him return to work and like nothing. So anyway, they didn't do that. Obviously, we brought the action. We said that he was not only did they breach the contract, the CBA, and the policy that was in place that he followed, but also that he was discriminated against under Florida law because the medical marijuana, as you guys know, is a constitutional right, and that he was discriminated against. because of that, and that medical marijuana is a valid prescription under Florida law. And anyway, we litigated the case, and the county admitted that he was never on site, never in the course and scope. Just had no issues with him being on work, and had exemplary performance reviews. And long story short, the court agreed with us and held that he was discriminated against and for presenting the card, and that the medical marijuana is a valid prescription, and that the county breached the CBA and the policy. And she granted our summary judgment on all counts. And it was a pretty significant ruling. And she drafted with our assistance, a 25-page opinion, and really just hammered the county and said that she actually said this, and this is a quote, she said that they have a silent agenda against people such as our client that use medical marijuana, and even though they test positive and they provide all the information needed and follow all the steps, that they have a silent agenda against medical marijuana. And
did they really say that? That's incredible.
Yeah, they actually said that, silent agenda.
Wow.
She included that. Yep. And that was
So, Mike, does that mean we got a precedent in state of Florida that we can actually use as case law?
Well, we do, and so right now, because it's the circuit court, it's just persuasive. And so, we got to get that appellate opinion. They are going to appeal. The other thing that we got the court to determine was that it was a prescription or non-prescription drug under Florida law, which is, again, another way you can justify using a substance. Typically, any drug-free workplace policy is, you get tested, you seriously have a period of time to provide for justification of why that substance is in your system. And so this is going to be great, Gary, and hopefully it can have some influence in the legislative session this year. I know I've been speaking to Mr. Eric Stevens, who's working with Florida for Care down about Miami. They've been going through and talking about their county policies down there, and that he's been, giving them some information on it. So hopefully this will change people's minds that they may be subject to lawsuit. And the same provision, not required to permit on-site use is what the amendment says. So the court also said that means that ipso facto that they have to permit off-site use.
Look at that giant glowing weed leaf behind you, Mike. That's awesome. I know particularly, I'm going to unmute Gary. Hopefully the echo is not crazy, but I know particularly this is like a pretty big thing for Gary, because Gary's been trying to push bills for worker protection for a while. Yeah, you definitely hear an echo, but Gary, can you talk about that a little bit? Is he frozen?
Oh, no. Oh, yeah, I hear you now.
Okay.
Yeah, I guess again, we started this thing because of the fact that we know that there are people who in the workplace who have been let go strictly for having a medical card, not because they're using it on site, which they weren't, and not because they were using it when they were not even on call. And EMTs especially are a particular aspect of the society where these people see things they cannot unsee. So many of them have ingrained PTSD. And I had a nice long conversation with Chad Cronister. Shout out to Chad for saying no thank you to Trump. We want to see you back here, if only just to make certain that your father-in-law's money continues to flow in Hillsborough County. But that's another story altogether. But the fact is, he said, well, our officers have yoga, they have acupuncture, they have various cognitive therapy sessions, and they're doing just fine as far as PTSD, only they're not. And so it is good to know that an EMT who uses it, again, well, not on shift or on call, so he can medicate at home, shows he can still be proficient at his job, hopefully, to make this go forward. And I'd like to see this precedent go nationwide, because there are labor agencies across the country who are dealing with this same issue. How are they dealing with it in California right now, Omar?
Well, as far as public safety professionals. There was a bill that had gotten vetoed by the governor that would have allowed off-duty use of medical cannabis, and so it's something that is now going before the governor again. And there was like, I think to your point about people being exposed to traumatic workplace events and using cannabis to basically wipe the slate clean so they can start anew the next shift. I think cannabis is extremely therapeutic for people who experience very traumatic, workplace incidents. So I think there's a lot to be said for cannabis for firefighters as well as EMTs and even police officers. But maybe not for them because they might need to remember all the facts. But for people who don't have to testify about what happened, and they're better off forgetting what happened, cannabis can definitely be super therapeutic. And so in California, we do have strong workplace protections for people who are not public safety professionals. I think there's now an increasing recognition that cannabis is superior to allopathic prescription medicines, such as painkillers or antidepressants or anything else that is, prescribed by psychiatrists for people who deal with all these workplace-related traumas. And so I think what we're going to see in the long run is a shift towards whole plant cannabis, just because it doesn't have all of the side effects. What's interesting is once they allow people to use cannabis after work and they realize like the sky did not fall, I think acceptance is going to grow, and it's going to, they're going to be reassured by the results. Just like they thought as soon as cannabis got legalized, even for medical purposes, they just thought like everybody was going to be stoned day and night, and cannabis was going to be sold out of ice cream trucks, and that never happened.
Oh man, but if I could buy ice cream and weed at the same time, that'd be great.
That's one of the sad things about this legalization regime. We used to have all sorts of like innovative products, including cannabis ice cream during the Wild West days of medical cannabis. And we no longer have that because of the regulations. You can't have like, these very perishable dairy products with cannabis in them under our current regulations.
And keep them in the refrigerator for several months. Yeah, people forget about edibles and shelf life, but that's another story altogether. But
we have a few of them, and one thing, on the employment issue, I think that a big impact will be when it finally moves to Schedule 3. It'll be a lot less of an impetus for companies and lawsuits related to them not having the ability to hide behind that it's a federal schedule or legal substance in these workplace issues. So I'm really excited about that. I think that's one of the 2 or 3 things that I actually think rescheduling will have an impact on.
And also, guys, the only other thing I wanted to say, sorry, I don't want to cut anybody off.
You're good, Larry. Go right ahead.
Yeah.
As a matter of fact, let's give you the floor here.
Regarding what Omar said, in the case of Mr. Giambroni, he had tried other medications, traditional medications that were prescribed by psychiatrists, and he had the side effects in the morning. He was groggy, he wasn't thinking straight, he wasn't himself, and then and the impact of the medication itself was not as significant as he would like, and so that was actually impacting his work. The traditional psychological or psychiatric medications were impacting his use, and then he switched to the medical marijuana that had a better impact on him. He woke up fine, he wasn't groggy, so it's really come full circle that it's actually had a better result for him using medical marijuana than traditional medication. So it was definitely the right ruling, but we'll have to see how it plays out in the appellate court.
Well, one of the most popular way of self-medicating is for PTSD is for law enforcement officers, EMTs, et cetera, to go home and take a 6-pack of Modelo Culadas. And that doesn't always go well as far as domestic violence is concerned, which oftentimes does occur in those particular industries. So hopefully we can get to a point where we can also reduce domestic violence within our first responders' homes. I think it's very valid in industry.
Yeah, and I mean, as you mentioned about Chronister before, but like within the past year and a half, we've had one officer just a couple of months ago commit suicide. We had another officer, was it earlier last year or earlier this year or late last year? The couple that were both law enforcement officers, where the husband or boyfriend killed the female officer and then killed himself, right? So in the last 2 years, we've had law enforcement situations which clearly show they're not mentally stable.
Yeah, we actually had a gentleman who had retired because of his PTSD and was brought back on as a resource officer after Marjorie Stoneman Douglas insisted on more resource officers go back into work. He went back to work, he got triggered, and he shot his grandkids and then himself afterwards. And that was in Hillsborough County and Plant City. So the results can go on and on and on. We have to find a way to resolve these kind of things, and we have to be on the same plane of thought with our legislators and our law enforcement. I'm hoping that we can move forward with this kind of stuff. And what is the result of this summary judgment? How is this going to affect your client? How is it going to affect the county?
Well, right now, the summary judgment does require them to accept a medical marijuana card as a valid prescription and require it as a negative test. So they are going to appeal. I am going to assume that they're going to move to stay the order pending appeal. So whether or not and when it'll have an impact, we're not quite sure. But, it is going to have an impact. And, like all lawsuits go, as you know, Gary, they take some time sometimes. And so hopefully we'll be able to defeat the stay and require them to accommodate all the other employees. Talking to firefighters all the time, I think probably at least 50% of them use cannabis pretty regularly. So, I think this is great for all of them. I've spoken to and I've heard from a couple other agencies and throughout the state, just saying, wow, this is awesome. And, we're hoping that this sticks for us. So. But you got to use it through the legislature this year. Let's do it.
How many years have you been on this case so far?
So this case, he was suspended early 2019.
Years in the making so far. And so the wheels of justice grind slowly, especially when they're grinding on top of the will of the people.
Yeah, and that had COVID in the middle too. So, it had a good year and a half delay as a result.
Yeah, I just had a case, not a non-medical cannabis case, but I had a case that was filed in late 22, and it actually got to trial last month, which is extraordinarily fast. So, in fact, my other colleagues were pretty surprised that I was able to get a case to trial so quickly. So, the wheels of justice turn very, very slowly. And to push a case through, you gotta. It's really it's a heavy haul.
Well, I have a question about this summary judgment ruling. So now that the government is appealing, right now the decision is persuasive, but it's not binding precedent. Let's say the appeal, is successful. You guys win again on appeal. On which courts would this appellate decision be binding?
So if we get a second appellate decision, it is binding on all circuit courts throughout the state.
Fantastic.
So really they would have to abide by these policies until an appellate decision in that state ruled differently, and then, hopefully certify conflict and go to the Florida Supreme Court.
Do you have like judicial districts, like appellate districts in Florida, or is it like, yeah? Uh-huh.
We have judicial districts in each circuit, and then we have appellate districts, which we have 6 appellate districts in the state.
Okay. And is there any prospect for like a civil rights lawsuit to get monetary compensation for the victim?
So we filed under Count 1, Florida Civil Rights Act. Yes. So we are seeking compensation under that. And then Count 4 was a breach of contract. So we are seeking all back pay, seniority, etc. with that. Anything else on that?
Attorney fees if you prevail? Nice.
Yep. Well, at least on the Civil Rights Act, yes. Not every count carries with it the attorney's fees, but the Civil Rights Act claim does carry with it attorney's fees. There's going to be a fight at some point after the entry of the judgment regarding there's a statutory cap in Florida on government agency tort claims, and so that's $200,000, and our claim, or our client's claim, is certainly going to exceed that. So we're going to have a fight over the amount of fees, the amount that our client gets eventually, and we've done some preliminary research, and we think we're going to prevail on certain aspects of that, but that fight has not yet happened.
And the reason I'm asking is because usually they only care if you hit them where it hurts, and that's the pocketbook.
Right.
Yeah.
Right.
Well, luckily for us in Florida, in order to be a cannabis lawyer, you must be an altruist. I think it's a prior.
All right, it looks like we have a comment in the Twitter comment section from our co-host. So I'm going to go ahead and I'm going to read Chris's question. Is it the Hillsborough County Administrator and Counsel that must appeal, or is it the elected commission allowed any input on the appealing?
So really, it's up to the fire department and his client and the county. I would say that would be the county administrator, really, and the attorneys as to whether or not they decide to do so.
Yeah, and they may have some kind of board of directors or board of committee that has input on it as to what the course of action is for or strategy for the lawyers to proceed. So I don't think it's anybody in particular.
Now, Omar, I'm not sure if you're familiar with this, but the fact is we have actually had great victories in the district courts here in Florida to help do things like allow home grow. And all those decisions were won at the district level and then appealed by the state at the behest of the governor, Rick Scott, who told Pam Bondi to go ahead and appeal every single victory decision we've had, and everyone has basically died after the appeal process drawn out ad infinitum, except for the one time where our governor was paid off to allow us to have a whole flower, which was very nice. Thanks to John Morgan and his bank book and whoever else worked on that particular thing.
Well, did you see the article, Gary, regarding the Gates and Morgan hookup?
Yeah.
So they mentioned that Gates is the one that organized that meeting and that deal.
Say that again, Mike, without Gary's echo.
So that deal, allegedly, according to the article, Morgan said Gates organized that situation, why we got home grow. You guys remember, right? The Winter Haven press conference with DeSantis, Gates, and John Morgan regarding allowing smokable flower, and that he was going to break up the monopoly and everything.
I remember it very well. Yeah. Let's carry back in there.
Yeah, just like a lot of our legislators and our executive branches, both in the state and the federal level, you can't always believe everything they say, but you have to assume that they are lying.
So, all right. So I know that Gary wants to talk about employee protection, but like, Mike, we were talking about THCA flower before. I don't know how much you want to talk about it, but I think it's important that you particularly are part of that conversation. I know you were in the back when we were talking about THCA and whether or not it's legal and what the legal challenges and all that. Do you have any comments from what we were talking about before?
Oh, I do, Carlos. So, number one, there's currently a lawsuit on appeal right now challenging the department's rules and regulations regarding THCA. The rub with the whole situation is the definition of hemp compared to the rules as to how they are supposed to carry out testing on hemp. In this, when I said federally illegal as well, the same week that they came out with the Miller Amendment, was all the news about rechanging the definition of THCA federally. 2 days later, the DEA came out and said, nope, THCA is already illegal because of this formula. That formula exists in a separate part of the rule from the definition of hemp, where it requires the USDA, state agencies, to come up with a decarboxylated testing procedure for the hemp to determine, the test results. So that's where that rub has lied, because clearly the definition of THC or hemp excludes tetrahydrocannabinolic acid, which is THCA, from the separate and apart from Delta 9, and then that separate testing requirement, seemingly how the feds in the states have defined decarboxylation, is basically turning THCA to Delta 9. So that's the conflict. And it's been a gray area. Some places confiscate it, some places don't. I think if a law enforcement walks into a shop and pulls a product and tests it, they're going to arrest someone for it. If FDAX walks into a shop in the state of Florida and they find it, depending on the inspector, they're going to issue a stop sale on it.
Mm-hmm. Mm-hmm. Well, you're familiar with you get random texts from me sometimes when I get scared when legal things happen. So you're familiar with what happened here in my shop. I actually had a stop sale placed on here, and they actually made me hold on to it and wait for law enforcement to come and pick it up, which scared the crap out of me. But actually, you'll be happy to know that they came about a month ago and took it out of the store.
Yeah, I'm amazed they came, because I have so many clients around the state who have top sales of sitting for months. One client got rid of it because it was perishable items, like what you guys were talking about before. So they're like moldy and gross, and they got rid of them. And they like, oh, where are these products? And they were moldy, they were disgusting, So if
Yeah,
that's
and quite honestly, I would not have expected them to come and pick them up. I don't know if you remember, but I CC'd you in an email, and your comment, I think, was like, oh, okay, we might as well pay attention to this guy.
Yeah, because and I told you were on there. They were on your email list, but they have had
Point of pride.
Products in their stores since last October. We still haven't picked anything up.
Yeah. Is there any movement from the FDAX at all? Like, is there like on statute right now that equation, or is there any movement by FDAX to put that equation into statute?
So that has been in the rule since 2021, since the first rules they submitted to the USDA. They have since redefined Delta 9 to be total THC as opposed to just Delta 9 THC, which we do believe is a usurpation of their power and a violation of the federal constitution. They've supremacy clause, etc., interstate commerce clause. As you were saying, Gary, my position is if it's compliant in another state and it's sold in interstate commerce to our state, you can't arrest someone here for purchasing it just because it's not compliant here. So, there's all those issues that keep me up at night.
Well, that's interesting. We have a problem with home grow, is that the NMTCs by definition are allowed to acquire clones for themselves. But if you had a home grow issue, nobody could actually sell them the clones as far as MMTCs, because they're allowed to acquire it, but they're not allowed to sell the clones themselves. They have to sell the product with people who have medical cards and things of that sort. That was one of the issues I was looking at when trying to create a home grow bill.
So, and Gary, that goes back to what our Supreme Court may do with our amendment and stuff, our lawsuit and stuff, and the home grow case, right? They said because it says you can possess a plant, whether or not it's growing or not, doesn't mean you can grow marijuana, because in this other section it uses the word cultivate. So we wish.
The Supreme Court brought it down to the word use. They would say when you're allowed to use cannabis doesn't necessarily mean you can grow it, just means you can smoke it. And so therefore they said therefore home grow is not legal because it's not defined as allowing cultivation as being part of use. I love how they play with one word, like or and, when it comes to our vertical and horizontal integration situation, which I think is still going on in Colorado, is it not, Omar, in regards to vertical and horizontal integration?
In Colorado, I'm not sure, but we had that same nonsense in California for a while, and they got rid of it. Except if you operate a testing lab, you're not allowed to have any other type of license. It makes sense. If you're a ref, you shouldn't be a player.
Yeah, well, we have that situation kind of. We still have people who own clinics next door to dispensaries.
Mhm.
When you actually have to get rent from the dispensary, uh, there's obviously some kind of conflict of interest there.
Yeah,
And
we had
I'm
that
not
in
putting anybody
California
out.
for quite a while, and then California started cracking down on non-medical professionals running medical cannabis recommendation clinics. But I think Florida does not have a prohibition on non-medical professionals running medical offices or owning medical offices. Is that right, Michael?
Larry, do you know that? I don't believe so.
Okay,
They
but in
just could
California,
be run by a marketing firm, etc., and stuff like that. And
yeah.
ironically, in our Hillsborough case, the attorney for the county multiple times insinuated that our medical marijuana doctors were not real doctors.
Yeah, yeah. That was pretty funny. I'll tell you that.
Gary's going off
The
there.
connection.
That the whole system of medical marijuana approval is apparently done, and certifications are provided from people that aren't medical doctors. That's pretty illogical and hilarious to me.
Well, we have people who are highly untrained behind the counter as well. Our ganjaneers, as you call them, Omar, are are basically clueless. We have a medical program which is essentially a quasi-medical program because you cannot come into a dispensary anywhere in Florida, MMTC, and ask a medical question. You will get the most dumbfounded look you have in your life, and they'll tell you how high it'll get you, or how quickly you'll get to sleep, or how quickly you'll get quote unquote creative. But that's not exactly what a person's asking when they want to know what particular cultivar is best for a migraine, or for glaucoma, or for any of the 10, unfortunately, qualifying conditions we have here to have a medical license here in Florida. We hope to change the medical program into an actual medical program by making certain there's actual some medical connection in the clinic, and that shouldn't just end when you leave your doctor's office. Who, as you said, may not even know enough about cannabis to know anything other than how to write your license, how to get your rec.
Yeah, that's a really good point. Like a lot of the doctors don't receive sufficient training on the endocannabinoid system. I hear that they're starting to teach that at some medical schools, but it ought to be mandatory teaching at all medical schools. And doctors should have a working knowledge of the endocannabinoid system if they're going to consider themselves doctors in this modern age. So I do think it's important if you're going to call yourself a medical cannabis program, to be able to answer patients' questions about medical cannabis and how to use it effectively. I could see from a liability perspective and from a FDA not wanting to make, health related statements perspective, how they would not want to be making those type of statements because it would invite FDA regulation.
So guys, it's been a great conversation. Gary, you're on mute, man. We're gonna need to go ahead and move on to the news. We want to give everybody a chance to kind of just go over who you are and how people can get a hold of you. I'm going to start off with Mike. I just have a question for him before he goes ahead, and then he can go into his whole spiel. But Mike, so you heard about Susan Valdez?
I did. How exciting is that, right?
Are you upset that you didn't run against her?
Oh, I mean, yeah, I guess. I just think that was just the most absurd thing I've ever seen in my I just cannot even believe it. If people don't know Ms. Valdez, she's a local representative here in Hillsborough County. She has been an incumbent for 3 terms now. She ran her 4th term as a Democrat. She then, before even getting sworn in for this next session, flipped to Republican. So I'm flabbergasted by it. These people are such hypocrites. That's why I'm an NPA now. Tried to run the Republican Party thing, so against the cannabis issue here in the state of Florida. I just couldn't do it. So I'm NPA, like John Morgan, seems like, and I just think we got to get these 2-party systems out of politics and let people have free will and vote on people as opposed to platforms in general.
Well, let's face it, Mike. You had a tough road to climb if you went into that district because it was so heavily Democratic. But luckily, Susan found a way to flip that district.
Yeah.
It's called "Fuck the Will of the Voters."
Right. It's called "I'll Just Pretend."
So Mike, go ahead, take a second, tell people who you are and how they can get a hold of you and support you.
Yeah, Michael Minardi with Minardi Law. You can reach out to Minardi Law. Friends of MCM, Friends of MCM is my political committee. And, hopefully we can continue to make changes here in the state, both legislatively, through the court system, and through the vote. So appreciate you guys, as always. Marty's the legal director of Normal, Florida. Omar, great to see you, man, always. It's been a long time. And it's just a great time to be a part of this industry, to part pushing cannabis law. And, we also work in the psychedelic space as well to kind of produce and push these natural remedies for people for healing and for spiritual enlightenment. And really excited the next couple of years.
Thank you very much. Larry, go ahead, give him your little spiel there.
Sure. I do the cases I work on the medical cannabis industry are primarily with Mike. I'm generally a civil litigator. I handle obviously these cases with Mike, but I also handle a variety of other things: medical malpractice, catastrophic injury, wrongful death, business litigation disputes, maritime cases. I mean, a whole host of things. That's really what I do, and I'm really have gotten into this field with Mike, and it's really quite interesting, and I want to continue working with him and others on it, and I hope to help other people that are in a similar situation, like our client, Mr. Giambroni. I think the court's ruling is right. I think the court's going to uphold it, and let's keep the fight going.
And Omar.
Yeah, I'm out in California, and I'm a lawyer, also a legal publisher, and I published a series of books on cannabis laws in California and New York, and basically trace the evolution of cannabis law and regulations. And then I'm also a ganjier instructor, and a ganjier is a cannabis sommelier, and I was fortunate enough to be invited to help develop the curriculum for cannabis sommeliers, along with Frenchie Canoli and Mel Frank and many cannabis luminaries. And we also developed the systematic assessment protocol for judging fine cannabis. And that was fun. Basically figure out how cannabis ought to be judged and, all the different criteria. And I've been fortunate that cannabis brought me here. It's a pleasure to be here.
And by the way, Frenchie of blessed memory, because he passed away this last year. He was a fantastic person. But I recommend these books to anybody who's got a counter staff who is as stupid as the average one that I've seen here in Florida. I'm sorry, uninformed. We love the less educated, but we don't want them behind the counter when we actually want answers. And that book gives us a lot of answers and helps people actually understand what the hell they're selling, as opposed to what talking points they were just given, or they cannot do any deep dive on.
That's right. I think, that cannabis, we're at the beginning of the industry, and there's so much more to learn in terms of the science, in terms of the effects on the human body, all the terpenes, how they interact with each other. And so we really are, babies, and there's so much more to be learned here. And I love, that the cannabis industry. It's really in its infancy, even though to a lot of us, I've been in the cannabis industry now for 26 years, and it feels like several lifetimes. And so if you want to be in an industry that gives you a lot of interesting life exposure, cannabis is it. You interact with all sorts of people, from the top of society to the very bottom, everything in between.
One quick question I want to ask you before we let you go, real quick. In California, there was the cannabis consumption lounge laws that came out of 1775. Does the state law pervade over the entire state, or once again, is it the localities that will actually have the ability to change that particular law at the city or county level?
So it's going to be the municipality that has the power to unlock the potential of state law. The state law is not self-executing across the whole state. The municipalities, the cities, and the counties have to enable cannabis lounges. And some of them are going to be doing so in short order because it increases revenue streams for the business and tax streams for local government.
Well, we know that's going to fly in San Francisco and in West Hollywood. How about like Sacramento?
Sacramento, yes, we have a pilot program for cannabis lounges, but more interesting, it's going to be like cannabis tourism possibilities. Like you'll be able to go to Humboldt County, Mendocino County, the Emerald Triangle, and experience cannabis in a lounge setting without having to be sneaking around in somebody's backyard and smoking some of the finest cannabis in the world that's local, that was grown within a few miles of where you are. So I think that's really the future of cannabis lounges, is like increasing cannabis tourism opportunities to places that are beyond the traditional West Hollywood, San Francisco dispensary scenes.
And with that, it's time for the normal news. And by the way, guys, you guys aren't getting kicked out or anything. If you guys need to go, but you can stay and comment on the news.
Oh, all right. At the top of the news hour, most important news story coming out is the DEA judge has provided a timeline for witness testimony in the marijuana rescheduling hearing. DEA Administrative Law Judge John Mulrooney has ordered witness testimony to begin in the matter of marijuana's federal classification as a Schedule I controlled substance on Tuesday, January 21st. Barring a stay in the proceedings, the witness testimony will take place every Tuesday, Wednesday, and Thursday through the week of March 3rd. Witnesses representing the DEA will testify on the first day of the trial. Though the agency is the designated proponent of the proposed rule to reclassify cannabis from Schedule I to Schedule III of the Federal Controlled Substances Act, its legal counsel has not yet provided any indication whether it will champion or challenge the policy change in court. During the pretrial hearing last week, which you can check out on normal.org, the judge gave the DEA until mid-December to provide its exhibits to the court. Each other participants in the hearing have already done so. Although Normal filed a notice of appeal and notice of intent to participate in the trial, it has been a party to past administrative petition efforts and hearings. It was not selected by the agency. Public comments to the DEA in July, Normal concurred with the views expressed by the Department of Health and Human Services that cannabis has currently accepted medical use and that the relatively low abuse potential is inconsistent with the criteria required for substances in either Schedule I or Schedule II. The majority of participants who have been selected to participate in the trial oppose the effort to remove cannabis from the Schedule I classification. Folks should understand that it was the Biden administration that initiated this regulatory process to review cannabis federal scheduling in late 2022, and this marks the fifth time that such an administrative petition to remove cannabis from the Schedule I from the CSA with Normal filing the initial petition in 1972. So again, that 72 petition had a ruling in the 80s, and the DA pretty much ignored their administrative law judge back then. So it remains to be seen how this will shake out. Now, let's talk about red state, blue state. Coming out of Illinois, the Illinois Supreme Court has ruled that the odor of raw cannabis is probable cause for motor vehicle search. We've seen other states strike it down. We've even seen other states post-legalization adopt rules where probable cause for a search for the smell of cannabis doesn't happen. But justices on the state Supreme Court of Illinois have determined that police can search a motor vehicle without a warrant based solely on the odor of raw cannabis emanating from the car. The majority decision hinged on statutory language in the state's vehicle code prohibiting the possession of cannabis in a motor vehicle unless it is sealed, odor-proof, child-resistant cannabis container. Lawmakers amended the code when it established regulations legalizing the adult use of marijuana in 2019. Violators of the law may face a civil or criminal penalties. Although cannabis may no longer be contraband in all circumstances, quote, users must possess and use cannabis in accordance with the laws, the majority of the court opined. When the odor of raw cannabis comes from a vehicle driven on an Illinois highway, it is almost certain that the cannabis is being possessed in violation of the vehicle code's odor-proof container requirement. They concluded in sum that we hold the odor of raw cannabis coming from a vehicle being operated on the Illinois highway alone sufficient to provide police officers who are trained and experienced in distinguishing between burnt and raw cannabis with probable cause to perform a warrantless search of the vehicle. The decision contrasts with a ruling issued by the courts months earlier with finding that police may not conduct a warrantless search of the vehicle based solely on the odor of burnt marijuana. Conflicting opinions defy the logic, justices wrote in their dissent. Though police officers frequently testify they can identify the presence of raw marijuana in a car solely based on odor, empirical studies have actually challenged these claims. Now, let's move on to some red state news. In Nebraska, opponents have filed a second lawsuit seeking to nullify the voter-approved medical marijuana initiatives. Former Marijuana State Senator John Quinn has filed a second lawsuit seeking to nullify two voter-approved medical cannabis access initiatives. Last month, a district court judge rejected another legal challenge that sought to invalidate the measure through the invalidating the signatures that put it on the ballot. That case is now being considered by the state Supreme Court, and Kuhn is filed is a party to that litigation as well. The latest suit argues that state officials cannot legally regulate medical cannabis because marijuana remains federally prohibited. The suit alleges in 2024, taxpayers paid for two statewide votes, to which together sought to obtain an objective that was unconstitutional, unlawful, and impossible: the legalization of manufacturing, dispensing, and profiting off marijuana products for so-called medical purposes. Voters overwhelmingly approved the two ballot measures, Measure 437 and Measure 438. 71% of voters decided in favor of Measure 437, which permits qualified patients to possess and use cannabis. 67% of voters backed Measure 438, which establishes a regulated system for the production and distribution of cannabis. Despite the pending lawsuits, Republican Governor Jim Pillen on Thursday signed proclamations codifying both in the law. In response to the litigation, Nebraskans for America Marijuana campaign manager Krista Eggers said that with 70% of support at the polls, Nebraska voters made it overwhelmingly clear they support safe and regulated medical cannabis access. The assertion that Nebraska's new medical cannabis laws violate the supremacy clause of the U.S. Constitution disregards decades of state-led independence and innovation. Under the 10th Amendment of the Constitution, states have the right to address the unique needs of their citizens without undue interference. The campaign remains committed to defending Nebraska's medical cannabis laws to ensure patients and families have access to those that they care about. The newly filed litigation in Nebraska is the latest in a series of legal efforts spearheaded by marijuana's legalization opponents. Since 2020, groups opposing marijuana policy reforms have litigated against a number of cannabis-related ballot measures, and in some cases, those efforts have resulted in measures either being struck from the ballot or having election results set aside. This is not democracy in America, ladies and gentlemen, but of course, we have a legal system and everything needs to go through its legal processes. Now, let's transition to talking about, medical value of cannabis. Okay, a recent study of survey data published in the Journal of Biometrical Journal showed that changes in marijuana's legal status doesn't soften the public stance towards driving under the influence. Adults express similar degrees of intolerance towards driving under the influence of marijuana, regardless if they live in a jurisdiction where cannabis is legal or illegal. Researchers affiliated with Ohio State University assessed the public's attitude and their willingness to drive after consuming marijuana in states where medical cannabis is legal and where it remains prohibited. They concluded the hypothesis that more liberal marijuana policies will lead to dangerous driving conditions was not corroborated by their analysis. In all three analyses, there was practically no evidence to reject the null hypothesis and to conclude that medical marijuana legalization leads to more tolerant behaviors and attitudes towards driving after marijuana use. In fact, they found practically no evidence for it. Researchers' findings are consistent with those in several prior studies. For instance, a 22 study conducted by investigators at the Research Triangle Institute reported current cannabis users in recreational and medical-only cannabis states were significantly less likely to report driving within 3 hours of getting high in the past 30 days compared to current users living in states without legal cannabis. All in all, what we see here is that folks still feel some type of way around cannabis and DUI. Now let's move on to other clinical things being published. The Journal of Southeast Asian Orthopedics has published clinical data that shows that the sublingual administration of oil extracts containing plant-derived cannabinoids significantly reduces knee pains in those suffering from treatment-resistant osteoarthritis. A team of Thai investigators conducted a randomized, double-blind, placebo-controlled clinical trial involving 32 patients diagnosed with severe osteopathic knee pain. All participants in the study were awaiting a total knee arthroplasty. Participants consumed either oral extracts containing THC, which was 4.5 milligrams per drop, and CBD with 24.25 milligrams per drop, or a placebo of coconut oil for 30 days. Patient pain scores demonstrated statistically significant improvement following the cannabis treatment. The authors concluded that cannabis oil significantly reduces pain intensity and improved quality of life in patients with osteoarthritis in their knees, as reflected by the improvements on the number scale. Future research with optimized doses and larger sample sizes obviously needs to be followed up. Now, one of the things, moving on to federal news, and I think this is important when we were just talking today and wrapping up about worker protections, is that commercially licensed drivers in America for the foreseeable future will continue to get urinalysis tests, despite the U.S. Department of Transportation amending its rules nearly 20 months ago to provide workers with the option of undergoing less invasive oral fluid testing as an alternative to urinalysis. Federal officials finalized the rule change on May 2nd, 2023. The new rule became effective June 1st, 2023. However, the rule stipulates that commercial drivers cannot opt for oral fluid testing until the U.S. Department of Health and Human Services certifies at least 2 laboratories to perform the saliva screening. In a recent notice published in the Federal Register, the agency acknowledges that no labs have received Health and Human certification. Because no oral fluid laboratories have been certified, it's not yet possible to comply with this provision, the agency said on December 9th. As a result, the agency is seeking to amend its May 2023 rule to require the conduct of directly observed urine tests in situations where oral fluid tests are currently required, but oral fluid testing is not yet available. Look, I want folks to understand that urinalysis in a legal society doesn't work. Urinalysis is for prohibition societies. You shouldn't have it at all in your system because it's illegal. We don't live in that type of world anymore. Therefore, urinalysis is not a scientific test of impairment. And as we try to repeal these drug laws, as we try to catch up with the way marijuana and medical marijuana laws address worker protections, we need to understand that urinalysis is an outdated form of testing. It does not indicate for an impairment. An oral fluid test typically identifies THC or its primary metabolite for a period of 12 to 24 hours following marijuana exposure. Understand that you can have urinalysis metabolites show up in your system months after consumption. And if you're a fat person like myself and you lose weight, it's stored in your fat cells. You can test positive for losing weight even years down the line. So understand that this is definitely something that we're going to continue to be on the front lines fighting for. Shout out to California Normal in continuing to stand up and fight for these. Thank you to Omar for being their legal counsel and doing that, making it happen. And as we wrap up this year and we head into the holidays, I do want to tell folks that there is an opportunity for you to do your part to pitch in and help out by donating your time, your treasure, your talent to your local Normal chapter. You can also go to National Normal store and website, and you can purchase Normal swag for your loved ones this holiday season. Again, all the proceeds go to the legalization movement and helping us do what we can here at Normal to make things happen. And of course, that one book that Gary always loves to hold up that I said should be required reading in every medical school, The Clinical Application for Cannabis and Cannabinoids, written by Normal Deputy Director Paul Mentano, is definitely a book that will help you argue with your relatives around the holiday dinner table up to the value of cannabis, both medically and in adult use situations. So again, do your part. Help us work to reform these marijuana laws. Donate your time, treasure, and talent. Go online to suncoastnormal.org, become a member of our chapter, and hit that like and subscribe button if you're watching right now across social media, and help us continue to bring you great content each and every week here on The Rotation. And that's the Normal News.
Now, truckers, I want you to know,
Jesus Christ.
I've got an echo here. I'm sorry about that. That
It's killing me,
I
dude.
don't think they can use the contents of a truck bomb as a just cause if they go ahead and check on it because of the chain of custody, just in case anybody throws a giant juice bottle full of urine out of their truck while they're driving.
Well, again, I want to say thank you, everyone, for joining us on the show today, and we'll see how everything shakes out, in the coming year in the administration. Between now and then, we have committee hearings happening in Florida. So again, write your state representatives. We're going to be putting out some action alerts where you can fill those out and send emails to your state reps asking them to support certain pieces of legislation, support the adoption of certain rules on the administrative side of things, and of course, continue to make this a state where one day soon, cannabis consumers will not be arrested, prosecuted, or discriminated against for using this God-given plant. And I want us to stop calling marijuana a drug. Drugs are made in laboratories, not Mother Nature's bountiful vagina.
And I guess that's the end of this episode. That's a great place to end. Bye-bye.